Yesterday, America got a ruling on Obamacare from the Supreme Court. An opinion authored by Chief Justice John Roberts upheld the legality of the individual mandate and most of the law that we've come to know as Obamacare. I have with me Attorney General Wayne Stenehjem from North Dakota. Mr. Stenehjem, you were one of the attorneys general nationally who joined our state into the lawsuit challenging Obamacare. What was your reaction when you heard this ruling?
Well, you almost have to resort to a thesaurus to look up as many synonyms for disappointed as you could find, because we were very, very disappointed. I guess if there's any bright spot in the entire ruling, it is this. The claim that the attorneys general brought was that a requirement imposed by Congress that every individual has to purchase a product violates the Commerce Clause of the Constitution was upheld by the court. A majority of the court, the Chief Justice plus the 4 dissenters, said, yes, the attorneys general are right. The Commerce Clause does not permit somebody to require, or does not permit Congress to require a person participate in commerce. So we kind of won on that count, and I hope as a precedent for the future that will be meaningful. But for today, it wasn't, because the Chief Justice then joined the liberal wing of the 4 liberal members of the court to say that, notwithstanding the fact that everybody in Congress said this was not a tax, notwithstanding that the majority leader of the U.S. Senate said that if this had been claimed to be a tax, it would not have passed, and notwithstanding the fact that the president himself said that he absolutely rejected the notion that this was a tax, the majority of the court said it's a tax. And that's what's very, very disappointing. Under the Constitution, of course, the taxing powers of the Congress is far broader than it is under the Commerce Clause. And as a result of that, the 5-4 majority held that that just about everything in the Affordable Care Act is constitutional, and that is something that we find to be terribly disappointing.
Even changing as it was from Congress's authority to regulate interstate commerce to Congress's authority to tax, it's still a little bit unprecedented here, because essentially what we're doing is we're being taxed for not doing something, right? I mean, we're taxing inactivity. That's
well, I agree. And the way that they impose it, this is the law of the land, and though I may disagree with it, the majority opinion says that it is a penalty for making a choice, not for not buying a product. And I understand that might be parsing, and I agree with you that it is an imposition of a tax for making a choice. That's, I guess, the way it is, and for now at least, it's something that we're going to have to live with. Although I think it may have been Mitt Romney himself who said that now there's one further appeal, and the appeal is ongoing, and the oral arguments are being held right now, and that's to the court of public opinion, because we have an election coming up, and I am sure that this issue will now be even more of a contentious one than it would have been had the law been overturned.
As an aside, politically speaking, I'm not so sure that there aren't some Democrats running for Congress this year who kind of wish this thing had gotten struck down. Now they're stuck, sort of having to support a very unpopular law. But it
is unpopular. It's unpopular nationally, and it's even more unpopular here in North Dakota. So, I guess those running for federal office are going to spend a lot of time talking about it, backpedaling, or announcing what their position is.
I think you're definitely right. I wanted to talk specifically. What does the ruling mean for the state, and a couple of different questions, because there was part of the law that was stricken down, and I want to talk about that. But first, during the last regular legislative session, the legislature passed a law that's on the books